everyone, we are members of Group 2, the students of the prestigious Faculty of Law, the Olabisi Onabanjo University. We're here to give you an insightful session about the essentials of a valid trust. We hope you find this insightful and educating. Thank you.
This is a trust. A trust is a fiduciary duty which a person who is the trustee holds property or assets in legal interest for the benefit of another person who is called the beneficiary. And this is created by someone who is the testator or the settlor.
There are two ways in which trust can be made, which is express trust and implied trust. Express trust is created by the act of the owner of the property, either by inter vivos or by will. And there are types of express trust, which are private trust, public trust, fixed trust, and discretionary trust. Second one is implied trust. Implied trust are trusts which arise from the presumed intention of the owner. Under this, we have resultant trust and constructive trust.
There are two exceptions to valid trust. You have capacity and certainty. And these certainties are divided into three. You have certainty of intention, certainty of subject matter, and certainty of object.
Essentials of a valid trust. The explanation of capacity means that the parties involved in creating the trust must have the legal ability to do so. The settlor, the person creating the trust, must be of sound mind, not a minor, and legally competent to transfer the property into the trust. Also, the trustee must be capable of holding and managing the trust of property for the benefit of the beneficiaries. In Nigeria, this principle was recognized in the case of Knight versus Knight, where the court emphasized that for a trust to be valid, there must be certainty and a competent person capable of creating the trust. Although the case is English, it is persuasive and widely applied in Nigerian trust law because Nigerian courts follow many common law principles on trust. Another Nigerian authority that reflects this principle is the case of Adeshaya versus Taiwo 1956, where the court acknowledged that a valid trust can only arise where the creator has the legal capacity and intention to create such trust. So in summary, capacity ensures that the trust created by someone legally recognized as competent, otherwise the trust may be declared invalid.
Certainty of intention. It is based on the equitable maxim, equity looks at intent and not the form. So ascertain the true intention. It must be very clear from the words used that the owner of the property actually intends to create the trust. And the words used must be imperative and not precatory. And the guiding principle here is what the party have said and not what the party means to say. Secondly, the words have to be examined to see whether an obligation of trust have been placed on the donee. In the case of Ray Adams against Kesinti, a testator gave all his real and personal estate to his wife with the full confidence that she was going to do what was right with the property as to the disposal of the property between his children. The court held that no trust was created because the testator was only placing a moral obligation as to use the money to provide for the children.
As regards the certainty of intention, there is the case of Musori Bank versus Relo. In this case, a husband created the trust in the name of his wife as the trustee, and he says he feels confident that the wife will divide the property and miss the children when she no longer needs it. The court holds that this case had no certainty of intention, as the word used by the husband was ambiguous. There is also the case of Lambe versus Ends. In this case, the husband leaves the trust in the discretion of his wife and states that she knows what to do and that it should be for the benefit of herself and the children whenever she deems fit. The court held that there was no certainty of intention in this case, as the words used by the husband were rather precatory rather than intentional.
Certainty of subject matter. The subject matter is also known as corpus of a trust. Now, the subject matter is the property upon which the manifested intention of a settlor or a testator is going to operate. That is, a corpus will not be created unless it has its existence. That is, when there is no existence, it will not be created. However, when there is a property without the existence of a subject matter, it will be called a contract, which is binding by the consideration. Now, we have the case of boys versus boys. Now, in the case of boys versus boys, he has two daughters with leaving a property of 4 houses. Now, he told the first daughter in the property, he gives the consideration or the condition that unless the first daughter has picked a house, then the 3 goes to the second daughter. Unfortunately, the first daughter died before the second daughter, the father itself. And during the course of sharing the property, they found out that the daughter could not take the remaining 3 because the first daughter has not picked any of the property, then it was made void.
We have the case of Curtis against Ripon, where the husband testator left his property to his wife, but added words asking her to use it for spiritual and temporal good, and that of the children, remembering always according to circumstances of the church and the poor. Issue here is whether this constituted a valid trust. The court determined that the trust failed because the beneficial shares could not be determined. What part was to be used for the wife, and what part was to be used for the children, and what portion was to be given to the church and the poor. Since the subject matter of the beneficiary's interest was uncertain, the trust was void because of uncertainty of subject matter, and the wife took the properties absolutely.
We have the certainty of objects. Certainty of objects requires that the beneficiary, that is the object of the trust, must be ascertainable. For a trust to be valid, the court must be able to ascertain, to know exactly who has the rights in the property and also who is entitled to the trust property.